Okay, awesome. Thank you everyone for being here for our webinar today about Special Needs Trust. I'm so happy to introduce Genevieve Gribble, who has presented for us many times before. We're so happy to have you back, and we're really grateful for this opportunity to learn about future planning and present planning and getting ready to just make our families successful and secure for the future.
I have to make sure I unmute there. So is there a way that I can share my screen?
Yes, you should have permissions for that.
Okay. Perfect. Let's see. Okay, can people see? My little, see if this will start.
Yeah, we can see that. Looks great.
Okay. So I have a variety of presentations I give on estate planning. My all-time favorite, I think I gave it the first time I presented, was it's, you know, how to train your dragon, because it was a conversation that I had with my nephew who's on the autism spectrum. And but this one, so I don't know if any of you know about Gucci bags. Okay, now I love Korean dramas, and I really got into them at the end of 2020. And the Korean women love bags, fancy bags. So I had a neighbor who had an estate sell, and it was a Korean couple who had moved and they had left all of these things. And I found a treasure trove of bags. And one of them actually said that it was Gucci. And I was so excited because I'd heard that Gucci bags were really awesome. And then I went online and I looked and I'm like, oh my word, this could be worth $5,000. So of course I would never pay $5,000 for, you know, a Gucci or any kind of bag. So I was just like, yes, I probably have this. I was just like, okay, but there are hallmarks because there's knockoffs on Gucci and other nice bags. And if we were in person, I would have brought a whole bunch of bags to show you because I have some really, really good bags. The one that's supposedly is Gucci, I'm not quite sure, but here are some hallmarks that if you are, or you know, looking over evaluating quality on a designer handbag, you look at the hardware, you look at the material, you look at the signature, and you look at the serial number. So, and my Gucci bag had some of these. So, but not all. I think it was missing one. But anyway, so what does this have to do with estate planning, and especially with special needs planning? So when you are doing special needs estate planning, that is a designer or a custom estate plan, because I do a lot of plans that are just, you know, kind of, I refer to them as like down the road. They're just like straight down the road plan. There really are no bumps in the road. We're not off-roading. It's just, hey, a very simple situation. But when you get involved in special needs, it's not a simple situation. There can be all sorts of things going on and all sorts of needs that need to be addressed. And so a special needs plan is a designer estate plan. It is a custom estate plan that needs to meet the needs of that particular situation. We want to look for strong, solidly built enclosures. Okay, this is like the zippers on a bag. They have these really awesome, like heavy metal ones that are just so cool and so strong. And we would say that, you know, the documents that we want to do would be those solidly, you know, those solidly built enclosures, like the trust, something that will, you know, be able to enclose assets and keep them safe. We want to make sure that we have the contingency language for all sorts of different scenarios that might, you know, show up. And then we want to have the personal details that really make it your plan. So we always say, and I am an estate planner, so we always say that every family needs a plan. I got into this business and when I graduated from law school, I had no intention of doing anything with estate planning. I thought it was really boring. I thought it was for old people. I just didn't see, how important it is. 2 months after I graduated, my cousin died suddenly at age 29, and he did not have an estate plan in place. He had 4 kids and a wife. He owned a business, and there were all sorts of questions about whether his wife could, do anything with that business. Were we going to have to go through probate? What was going to happen? There was an interesting thing. He was an artist, and he had lots of paintings that he'd done and lots of art that might be part of the business, might be owned by them, or could his wife, claim that? So there were lots of different questions, and not having an estate plan in place created a lot of issues. And I was able to go down to their small town and work with an estate planning attorney there and get everything settled and get things worked out for his wife. And it was such a rewarding experience. And I went from having this attitude that it's only for old people to recognizing that people of all ages have some sort of estate planning need. You can be 18 and need to have, you're going to go on a mission or go on an, study abroad, or, do something. You're going to go sell, pest control stuff, door to door in a different state. You should have a set of documents done. Your estate plan might not involve, owning a home and, putting that in a trust or anything like that, but it could be as simple as having a power of attorney and having healthcare documents, so that if something untoward happens while you're out and about, your parents or whoever you have designated as your agent can do things for you. Now, most families need a trust plan rather than just a simple will. I've met many people who have told me, well, they'll tell me what they need. And a lot of times it starts off with, I have a really simple situation. All I need is a simple will. And in fact, I know some estate planners who that is their tagline, and they just say, hey, you just need a simple will. A lot of times you need more than just a simple will, especially if you own real property. And we'll get into that. So proper planning should include these following 3 things: a life plan, a transfer plan, and a family plan. So the life plan, you just think about as you're going about, conducting business. A transfer plan, how are things going to be transferred, when you pass on? And then a family plan. This is something that's really important, because a lot of times we don't think about the fact that when we're gone, our children might be in a sort of an unstable situation. And we want to do everything we can to maintain stability in the family, so that, and I'm sure everybody has heard stories of families falling apart when the parents pass on, and just becoming, they're at war over things maybe were done unfairly, or they weren't done clearly. That is something we really run into a lot, is things just weren't clear. And there's one sibling who is very pushy, and that person just overwhelms everybody else and gets their way. And it can be a really, it can be very divisive. So it is important to make sure that you've got a plan in place that will protect the family and keep, as much as possible, keep those bonds strong. So let's talk about the special needs child in relation to all of this. So there's a timeline for special needs. You have from birth to age 18. Normally they're under the care of their parents, and they're not, oftentimes they're not eligible for public assistance benefits, because the government's going to look at the parent's income and make a decision based on that. Once that child turns 18, then the parent's resources end, and the child may qualify for public assistance. And here's the other kicker here. Parents' authority to make legal decisions for the child ends at age 18. And this one can be a real big surprise to parents, because you as a parent are very well aware of the limitations that your child may have, especially just in, their daily lives, like how that disability impacts their ability to, do things. And so you may think, especially if you have a child who's severely disabled, you may think, well, how could they be, how could they have any how could they be an adult legally and have adult rights? Because they're really, like if you have a child that's the age, mentally of a 2-year-old or, a 4-year-old, it's kind of hard to think that you might actually need to, that your authority has ended when they turn 18, but legally, your authority has ended. And they're, a lot of kids are just kind of kept close. They're at home. There's no problem, but sometimes their problems arise and parents are not prepared to deal with the issues that come up because they haven't even considered that they may not be in charge anymore. I'll give a really quick example. We had a client a few years ago who, her daughter was 19. She was disabled. She had a job, a little voc rehab she was, involved in. And so she would go on the bus a couple times a week and go to this job. And she knew where to get off the bus. One day she inadvertently missed her stop. She never got off the bus. So she didn't know what to do. She just stayed on the bus until the very end of the route. And the bus driver was like, you've got to get off here. And, in talking with this individual, he realized she had some issues. And so he called the police. The police came, got involved. My client got a call from the police and they said, well, we have your child, but they couldn't explain everything that was going on because the child had said, oh, my mom's going to be so mad at me if she finds out I missed my bus stop. So don't tell my mom where I am. And you think of that as being like, as a parent of a child with a disability, how frightened you would be if you didn't know where your child was, because you are like, you want to run and help them. But because that child was 19 and she said, don't tell my parent, the police couldn't give information. They weren't authorized to do that. So anyway, we ended up helping that client get a guardianship in place so that she could actually, be of assistance. But there are things that you'll want to consider as your child is getting older. Okay, here are some common planning mistakes. And I'm just going to go over a few. I might not cover all of them. Okay, the first one, I'm actually going to say the first one is not putting things in writing. I need to reverse this because this is the biggest problem that I see is that I will come across, I'll run into parents and they will say, I have talked to my children. I have told them what we've told them what we want to have happen. Okay. Actually having multiple conversations with your children is very good, but it has no force in court. Your kids cannot go into court and say, my mom wanted this done. She told me so many times over the dinner table as we were eating that she wanted us to do A, B, C, when she passed away. Doesn't matter. There's no way to prove it. You have to put things in writing. Things have to be written down. A lot of times they have to be signed and signed in a certain way, but they have to be put in writing. So that is the first mistake. And that's what I want everybody to, don't make that mistake. Put everything in writing that you want to have happen. Then there is such a higher chance that it will actually happen. Okay, let's talk about disinheriting the child and not planning around benefits, because those two are actually the flip side of each other. So on the one side, we have disinheriting the child. A lot of people have heard if your child receives an inheritance, they will disqualify for receiving public benefits. So the answer to that is, let's not give the child an inheritance. Let's disinherit the child. Okay, so that's one side of the coin. The other side of the coin is parents may not even think about planning around those benefits. So they may, just their child's going to receive an outright inheritance. And as soon as they do, they're going to disqualify for receiving public benefits. What we want to do is so the public benefits have a great value that I feel like is above the face value, especially the medical component. We want the children to be able to receive whatever they're entitled to legally. But if that is all your child is living on, if that is all they have, your child is at subsistence level, and your child may end up being homeless. If that is all they are depending on, or in just a situation that most parents would not want their children to be in. On the flip side, if your child receives an outright inheritance, they may not have any ability to manage money. So they may waste it. I have a brother who's disabled, and I can tell you that any money he gets is gone just like that. And a lot of times it goes to people who are, I would call them predators. They tell him they're his friends. But he's very vulnerable to being taken advantage of financially. And many people are in that situation. Sure, if he receives an inheritance outright, it will be gone because of his own, poor financial decisions, but also other people will be bound to come forward and help him spend all of his money. So that's a situation that we often see happen. What we want to have is we want to keep the benefits, but we want to have the inheritance, and we want to have the inheritance received in a way that it does not interfere with the benefits. And how we do that is through a special needs trust. The kind that is basically the gold standard of special needs trust is the third party special needs trust, which means there's no connection between the assets in the trust and the individual with the disability. And what that does is it means that that money can be used, whatever's in there, the trustee can use that to raise that standard of living that the child has. So they can, let's say, the child wants to go on a trip to Disneyland or, wherever. They can go, they can have, usually they can have a companion paid for. So we're not just envisioning them hopping off alone, on a vacation, but they can have paid out of that trust, can be a vacation and a companion. For that vacation, there's all sorts of goods and things that could be paid for: a computer, an iPad, different therapies, things that are not covered by the government. So those extra things. So what that does is the child continues to receive their benefits, and then that whatever is in the trust just helps to raise that standard of living so that they are in a comfortable situation, in a safe situation. Another thing that happens is parents will say they're going to rely on their other children. So especially where, the child may come from a larger family, there are times when you will see these really great relationships between kids. And there may be a sibling who has always been very helpful and always, really close to that sibling with the disability. The issue is that as those kids get older, so what will happen is parents will say, well, and this kind of goes along with the disinheriting, because what they'll do is they'll give that child who's the friend of the other sibling, or the sibling with the disability, they'll give them a double portion. So they disinherit the first, the child with the disability, and they give their, helping child the double portion. But the thing is there's no connection between, and there's no, it's not so much connection as there is no requirement on the part of that individual who's received the double inheritance to share with the child with the disability. And a lot of parents are hesitant to believe that their children would not do what they've asked them to do. And that does actually happen. Like when people pass away, sometimes their kids do things that, they would never think their kids would do. But even when their kids, with the best intentions possible, try to carry out the parents' plan, there are things that can intervene. For example, let's say that parents pass away. John, the brother who is not disabled, receives a double portion with the caveat that he will be sharing with his younger brother, Jim, who's disabled. He may start to do that, but maybe John is married and maybe his marriage starts to fail. And it could happen that half of that inheritance might end up going out the door. It might end up in a divorce, going with, we'd hate to see that happen, but it could be that would happen. especially if the funds were commingled or, anything like that. And then there's also a situation where, let's say that, John inherits and then he passes away. That money does not have a connection to Jim. The law is not going to require that money, that half of it be given to Jim. It's going to go to John's wife. It's going to go to his children. So these things can happen inadvertently that will frustrate the desires and the intentions of parents when you're relying, just on your children to do things that you want. So, okay, we're gonna hop to the other one. Okay, so when you're talking about a complete special needs trust plan, it includes a lot of stuff. So you have the special needs trust document, and I'll go over some different ways that can look, because it can be, it could be testamentary, which means that it comes about because of a trust or a will. It could be third party, it could be self-settled, or it could be pooled. It also, your trust plan would have powers of attorney, healthcare directives and HIPAA authorizations, pour-over wills that have guardian designations in them, a care plan, and then it may involve guardianship. For funding of the plan, we look at life insurance. That really is such a great way. Annuities can be used sometimes too. But you have to watch and make sure that the income limits of the beneficiary don't get exceeded. Okay, now here are the benefits of a special needs trust. It protects the eligibility of the individual for government benefits, provides for a higher quality of life, provides framework for care and management of assets. It allows the parents to express their desires. It protects assets from creditors and predators because it's never in the hands of the individual. And it extends the life of assets. This is a really important point with the third-party special needs trust, because when the individual with the disability passes away, whatever is left in the third-party special needs trust, there are residuary beneficiaries who are listed, and they can be, it could be a charity, it could be your other children, it could be, if your child with a disability is married and has kids of their own, it could be their children, but it remains in the family. It can remain in the family, okay? If the money is connected to the child with the disability, when they pass away, the government can do what is called government estate recovery. And they can step in and pay themselves back for everything that they have disbursed on behalf of the individual with the disability during their lifetime, which can be a considerable amount. So having it in a special needs trust prevents that from happening, which is really important. Okay, and I think I just told you these things, basically. The reason why the government cannot exercise estate recovery is because the individual with the disability has no control over the money. They cannot say, you are going to give me XYZ. It is completely up to the trustee. So, okay, now there are first party or self-settled special needs trusts. And I mentioned before that the third party special needs trust, those are the gold standard. And they are the gold standard, but there are many reasons why you might need a first party special needs trust. And they are definitely a good tool to realize that you have in your toolbox. For example, if your child is in an accident of some kind and they receive a settlement, their money that settlement money could prevent them from, or disqualify them from receiving government benefits. But if you put it in a first party special needs trust, it will not disqualify them. Okay, so now the downside of that is that because that money has been received by the individual with the disability and it belongs to them, the government can exercise estate recovery on whatever is left after that individual passes away. So the residuary beneficiary, the primary one, is the government. Then after they've paid themselves back, then you can have further residuary beneficiaries. But a lot of times the government takes, they kind of scoop the lot. Okay. Now, there is a way so here are some reasons. Let's say that you have, and it really does depend on how old your child is. Okay. Well, it can. Let's say your child is 2 or 3. They're disabled. But right now you're not really concerned about putting money away for them. They're just, you're just raising them. You need an estate plan as a parent because you probably own a home. It should be put into a trust. You also need a will. Your child is a minor, so you need to, a will is where you designate guardianship. Okay, sorry. My hair is really super staticky. I feel like it's attacking my face. Anyway, okay, sorry. That was totally unprofessional, but I think you can tell that my hair is being unprofessional. It's not me. Okay, so, let me get back to where I was. So in your plan, you can do this where you have, where you don't do a standalone special needs trust, but instead you put provisions within your trust that say, okay, when we pass away, then any portion of our, of our assets that goes to this individual with the disability, or a child with the disability, it will be held in trust in a special needs trust that's a third-party special needs trust. They'll never receive anything right. Does someone have a question?
I think someone just jumped on and they weren't muted.
Oh, okay. So, so you have those instructions, those provisions within your trust, but the trust isn't established until the last parent passes away or the last, trust maker passes away. And the nice thing about that is that you don't have the cost of setting up a special needs trust immediately. But, and that can be really, that can be very helpful because a lot of times there are lots of calls on your money, and especially when you have a child with a disability, that can be expensive. So that is a way to do it. But let's say that you have a different scenario. Your child's older, they're, you want to, and you feel like you want to set something up so that you can have life insurance that you make the trust the beneficiary of. You can't make life insurance you cannot make the provisions the beneficiary of your life insurance. Okay. You can only make a trust that is already established the beneficiary. So if you're ready to do that, you'll set up a third-party special needs trust and you'll make it the beneficiary of life insurance. You can make it the beneficiary of your trust. You can do all sorts of things to fund that. So that can be done. One of the things, though, is to consider if you are thinking about, do we want to do the provisions? Do we want to do a standalone one? Is if you think that somebody in your family is going to leave something to your child with the disability, because this happens quite often where a grandparent or an aunt or uncle, really dotes on I call them doting aunties, but they're doting relatives. They really dote on that child and they want to leave them something. And a lot of times they will leave it to them outright. And what we want to have happen is we want to have that left instead to a trust, to a special needs trust. So if anybody, makes any sign that they're going to do that, it's time to have a conversation and say, hey, you know what? We love it that you're leaving something to our child, but it would save so many problems, pardon me, if you left it to them, left it to the trust that we've established for them. Having the provisions is a really good safety measure, but sometimes I have come across people who have gotten confused. And, there were the special needs trust provisions were in there, but for some reason they were never, put into motion. So although they are a good thing to have in there, if you're not, prepared at that moment to set up a special needs trust, an outright one or a standalone one, they're still, they're very good, but they can be kind of confusing. Okay. So yeah, I don't know. You know what? I think that sounded confusing. So I apologize. I think I explained not very well, but okay. Let's go on and talk about an ABLE account. So a lot of times people will say, if I've set up a third-party special needs trust for my child, one of the provisions is you can't just give them money. Okay, so the trust can't just make a payout to that individual. But your child, and especially when your children get older, they want to have some money, like my nephew he's almost 19, he has a wallet and he'll always say to me, Auntie V, look, my wallet is empty now. And he knows that I'm going to go, get $10 or something and give him money. He loves to have some money in his wallet and be able to pay for things himself. It is just, and I think most people like that freedom and they like the ability to do that. It's also, there's something very self-respecting about being able to save money. Okay. But when you are receiving government benefits, a lot of times you're limited to having assets that are no more than $2,000. So a way to get around this is to establish an ABLE account. Now, the ABLE account, there are all sorts of different, rules on it, but the main thing is that whatever money is in there, and so this is the thing to keep in mind. A lot of times parents will say, well, let's just set up an ABLE account. It's kind of free to set this up. Let's not do a special needs trust. And then we'll just, put money in the ABLE account. The ABLE account is the same. It has that same drawback that a first party special needs trust has, which is the payable on death beneficiary of an ABLE account is the government. Okay. So, but the nice thing about it is you can have up to $15,000. It goes along with gifting exemptions. You can have, close to $15,000 a year can be put into the account from all sources. Also, the individual with the disability, if they have a job, they can contribute, I think it is close to $15,000 a year as well. So, the individual could end up having like $30,000 in there, and the assets can be available to the beneficiary. They have a debit card, they can, use that and pay for things. Okay. And whatever's in there, and it can get up, the limits are really high. They could have close to $100,000 in there in most instances. In some states, they have beyond that. So you can have a lot, but let's look at it this way. If you have money of your own, it's not the best idea to put it into the ABLE account, because then that money is, it's going to be gobbled up by the government if your child doesn't use it, but it will end up going to the government to pay them back. So instead, what you can do is you put whatever you're going to put into the special needs trust, and then you have the special needs trust pay out, $400 a month into the ABLE account. And it has provisions within there that say, yes, it can pay out to an ABLE account, pays out that money, and then your child has money, but not huge amounts. Like I'm saying, this has a purpose. We really like it. We want to be able to use it. We just don't want to use it for something that it would be more sensible to use, a different vehicle for. Another drawback, it's not necessarily a drawback, but real property can't be held in the ABLE account. where a special needs trust can own a house. You can buy a house and put it in the trust for your children, for your child. And the third party trust, I just used the word children. You can have other children other than your child with a disability as beneficiaries of the third party trust if you want to. So. Okay. Now the details of the power of attorney and healthcare power of attorney. We are at 4:38. Sylvia, can I ask you real quick, how long do we want to leave for questions?
That is completely up to you. I think at least, maybe 10 minutes or so, if that's possible, but
Okay.
yeah,
Okay,
that's up to you
perfect.
and to our participants that are on the call.
Okay, I think what I'll do is just briefly, I'm going to pop over to guardianship. I know you mentioned special needs trust as specifically, but is it okay if I touch on guardianship as well?
Absolutely, absolutely.
Okay. Okay, last will and testament. Let's plan. That's something that I would discuss. Okay. So here, guardianships, powers of attorney, or supported decision-making agreements. Okay, so right now, or maybe not right now, but before your child turns 18, you're the legal guardians. Okay. So you have the power to, act for them, make decisions for them, all of that. Once your child turns 18, you no longer do. And I mentioned before, this can be a bit of a shock to parents. One of the funniest things, it's not funny because it can be dangerous, but kind of interesting thing is that when a child turns 18, they can check themselves out of school. Who knew? Like I didn't know that. Of course, I didn't turn 18 until after I graduated from high school, but I guess all of my friends who turned 18, they could have checked themselves out of high school. So this really isn't something that most of us want any of our children doing, but especially a child with a disability, you really don't want them checking themselves out. But they have all sorts of things can happen. Like let's say medical things. Once that child turns 18, and sometimes doctors don't do this, but once your child turns 18, you have no right to be there when the doctor is discussing things with them. And I don't know, I don't know how everybody's situation is with their children, but my nephew, he would be very prepared to say, I don't want mom here, or I don't want dad here, or, if he was told, hey, it's up to you. So there are times when, and let's face it, if your child needed an operation, they needed to say yes, maybe they're going to say no, because, hey, if it's up to them, they don't want the pain of it, So here are things that you're going to think about on guardianship. You can apply for guardianship of your child once your child turns 17 years and 6 months. Okay, so the court will entertain a petition at that time. The guardianship would go into place or go into force once your child turns 18. Okay, so courts are they frown on guardianship in a manner of speaking, because guardianship is taking somebody's rights away and giving them to somebody else to exercise. Okay. Now, sometimes that gets kind of scary for parents. I've had a parent who was like, I don't want to become a tyrant, and I'm like, okay, if you're not a tyrant as a parent, like just if you're not right now, getting guardianship isn't going to make you a tyrant. Okay. But it can help you to help your child. It's a very good thing when your child does not have the, I always think of it as becoming an adult is not just about exercising rights, it's about taking responsibility. If your child doesn't have the ability to take the responsibility, then they probably need some help with guardianship. But going back to how courts look at this, a court will prefer a limited guardianship to a full guardianship. If your child needs a full guardianship, though, you are going to petition for a full guardianship because you want to be focused on what your child needs. Okay. But if there's a reason why, if your child doesn't actually need a full guardianship, you're going to need to do a limited guardianship. In a limited guardianship, all it means is that you ask for specific things instead of it just being a blanket thing. So you can limit it to areas that are very useful. And these are things I would think of as a parent: financial, residential, medical. Those, if you limit the guardianship to those 3 areas, you can do educational as well. If you limit the guardianship, it is a limited guardianship, but those areas are very key areas. Okay. When you think about, okay, I really am giving too much information here. Let's back up. Now I've listed representation here. So representation, you as parents, as petitioners, if you're petitioning the court, you actually don't have to be represented by counsel. Now, some people want to be represented by counsel. Some people should be represented by counsel just because they have a kind of a difficult situation. And then some people, they really don't need to be represented by counsel. There's an online court assistance program. It's called OCAP, or is the little initials. And you can go and you can fill out the documents and you can apply for guardianship. You can petition the court for guardianship. I've met all sorts of individuals. Some people are like, I just want to have an attorney do it so that I know it's done right, so that everything is filed and there's no issue. Okay, that can be very valid. I've also met people who I was like, I don't know if they're actually going to do this, who did it like within 24 hours. They had done all of the documents, gotten everything done. I didn't even think they were very tech savvy, and they just did it because they were just that kind of person. I've also met people who said they were going to do it and they filled out some documents. 3 years later, it still hasn't taken place. Like they're just, I don't know. Okay, so you have to know what kind of person you are, and if you want to, anyway. But I would welcome having a conversation with you to, decide what you want to do. Now, your child is supposed to be represented by counsel. Okay, so you don't have to be, but your child has to be, except for some very narrow, so the statute, this is the funny thing, the statute has these requirements if your child is not going to be represented by counsel, but a lot of times there's this one piece that parents don't do, and the courts, I've seen the judges have not kept them to it, haven't required it, but it makes me nervous. And I've talked with a couple of lawyers and people who are legal experts about it, and it's kind of disquieting, because if your child is not represented by counsel and you don't have this one piece, if there was ever a question, that could come back and bite you. Okay, I mean, we've all heard about Britney Spears and the conservatorship that her, father had over her. We don't want to have a scandal, we don't want to be part of that. But what this thing is that if your child is not going to be represented by counsel and you meet all of the requirements for that, which is parents, you have to be the parents of the child and blah, blah, blah. You still have to have a court visitor assigned to go and investigate and just talk with all the parties. But our court visitor program is overwhelmed right now. So it's like a 4-month wait. There's like a waiting list. And so it takes a long time, but it's also, I've worked with the court visitor program, and it is a very, very good program, but you don't know who you're going to get. I had one time when I had somebody assigned who I felt like did not understand disability. And she looked at the situation that my client was in and her daughter and said, oh, this child seems perfectly fine to, just be on her own. She didn't recognize that there was this entire framework that these parents had put in place to support this child. And if they weren't there, or if they removed those supports, that child would just crash. So I felt like there were, so this is my thing. I don't like to go into court not knowing what's going to happen. So I like to say, let's know who is representing your child. Let's, I feel like it's a better thing to just have your child represented. Then there's no, I don't know. Anyway, but that is me. And then let me see what the time is, because goodness. Okay, 2 more minutes, really quickly. You can do a power of attorney. You can ask your child to sign a power of attorney and healthcare documents. Okay. And a lot of times people will say, well, that's so much easier. You don't have to, go to court for that. So, it's just a private document. This is the thing. Power of attorney is permission to act for your child. It does not remove any of their rights, which means that your child is still able to act. They can still go on. And so I'll give an example. If I had a client who, it was a sibling. So the siblings were getting guardianship over their brother with a disability. Before we went to court, the brother went on a weekend and took some money and he bought a truck. He didn't need a truck. It was just this kind of crazy purchase. But he, signed the documents, everything, and he got this truck. They went back in on Monday and the, dealership was very understanding and they unwound the transaction. It did cost them $500 to get out of that, and it was like $20,000 for the truck. So $500, that was, was totally worth it to be able to get out of that contract. But here's the thing. If you have guardianship or conservatorship and your child goes and buys a truck and signs something, that contract will be completely unwound and there will be no money owed. Okay. And this is something that can really, it's surprising the situations that can come up that you think, you don't even think about. So I've shared this before, but my brother with the disability, he co-signed a contract for a gym membership for an entire rugby team. These guys were his friends. He was not on the rugby team. He had a back injury. He never went to the gym. They told him, you'll never have to pay a dime. It's just co-signing. He co-signed and then they didn't pay the fee. And then my brother, but it was really our family, ended up paying almost $4,000 to get him out of that contract. If my parents had guardianship, it would have been simply presenting the letters of guardianship and saying this person does not have the legal capacity to make a contract. This has to be unwound and he doesn't have to pay anything. So that is a lot more power than, just having a power of attorney, which is like, yeah, your child is still free to go out and make all sorts of financial decisions and contract and do all of this stuff, even when it's not in his best interest. Anyway, okay. And then there is supported decision-making. So supported decision-making, it can be helpful. I have met some people where I felt like it was appropriate, but what it is it doesn't have teeth. So it's an agreement that your child would make with you or with, other people, where these people would say, you know what, we will help you make decisions. But see, there's nothing in it that says that your child can't just go off and make some really poor decisions, that it's up to them, And so, yeah. Okay. I'm going to end now and open it up for questions.
We do have 2 questions in the chat right now. I'll read the first one.
Okay.
Recently, I had to apply for Medicaid for my husband that was pulled from the DSPD list. I was told that anything not in our family trust for 60 months is subject to repayment to Medicaid if he passes before the trust is 5 years old. Is this the same as our special needs trust? Do they look back at how long the trust is in effect? Or do they just look at how long they have been getting benefits and if they had a special needs trust since nothing has been in their name?
So here, the issue here, what they're talking about is the 5-year look back that Medicaid has. So what they're saying is putting something into, so let's say that, you know, you have a special needs trust set up and you put something into it. And actually that's not. Okay. What they're looking for is disqualifying asset transfers. Because what happens is people, and this is the whole reason why people would do like self-help when they're, we call it self-help Medicaid planning. When you put all of your children, you go off the deed on your house. So you take your name off and you put your children's names on. Because what you're doing is you're saying, if I go into long-term care, I don't want the government to be able to come back and put a lien on the house and pay themselves back. Okay. So I really want the house to go to my kids. So there used to be a look back that was 3 years long. So what they do is they look back for 3 years. Now it's 5 years. So let's skip over that. So what they'll do is they'll look back 5 years and they would say, okay, in that 5 years, have you gotten rid of an asset in a way that would be considered a disqualifying asset transfer? And what disqualifies you is when you give up an asset and you don't get something of value in return. Okay. So if you were like, let's say that you were, 36 months back, you gave your house to your children. That is a disqualifying asset transfer. Okay. But if you gave your house to your children in 60 months past, 61 months past, that's not disqualifying because it's not within that 5-year look back. Did I answer your question?
Mostly I'm just wondering if the same rules apply to our special needs kids. Like just say they got some life insurance that were put into their special needs trust and the special needs trust hasn't been open for the 60 months. Can they come and get repayment for the Medicaid services that they've had?
No, because
Okay.
the thing is that the special needs trust is not, the money is not your child's. They're going to look at the child, that individual, and they're going to say, did they do a disqualifying asset transfer? Okay. And your child hasn't, because life insurance that has gone into the trust that they have no control over. No, they had nothing to do with that.
Would that be the same with an ABLE account?
An ABLE account, the thing with the ABLE account is it automatically is going to, whatever is left when that individual passes away, the government is the payable on death beneficiary. Okay. So that's why we don't encourage you to save money in the ABLE account. We encourage you to save money in the third party special needs trust, because it's got residuary beneficiaries of whoever you want, family or whatever, but not the government.
Great, thank you.
You're welcome.
Our next question is, if an adult child is receiving DSPD services, how much financial support will they require? I'm just trying to figure out what a reasonable amount to save would be.
You know what? I have no idea. I mean, it really depends. I think, the DSPD services are very valuable. If your child has a place to live and they have, I would look at what they're receiving and just say, what do I give? Like if you can look at what they're getting right now and then say, okay, this is what I give that's extra. This is what I'm spending. And then, do the whole inflation thing. And then you can figure out what they may need. Okay, but I would definitely err on the side of doing more, too much, than doing too little. I've seen a couple of very sad situations where I've had parents who just they didn't really plan, and then it's kind of too late, they've aged, they're not, making tons of money to put away, and it's like, okay, we don't know what's going to happen now. So definitely I would err on doing too much rather than, maybe being short. Yeah. Anyone else? Or is there another message?
We have one more in the chat. We will
Okay.
send out a recording of the session, but there's also a request to put up the screen that has the complete complete SMT plan.
Yeah,
So
let
you
me
can,
do that.
take a picture, jot it down. Thank you.
Yeah, let me find that. Mhm.
Yeah, and then we'll send, Trish, we'll send a recording out. Usually takes a little bit of time for Zoom to process it, and then we will send this out to everyone. So if you missed something, or if you know someone that wanted to attend but couldn't, we'll have that out either later this evening or early tomorrow morning.
And then, I'll put my contact info in the chat. And if anybody wants to reach out to me, I'm totally willing to meet. I do offer a free consultation. If you just have questions that are more, specific to your situation. Okay, can you all see that?
Yes.
Okay, perfect. Okay, now, does anybody else have any questions? Because we're right here at the hour. But I know we got started a little bit late, so. Hmm. Okay, has everybody had time to get that?
And Genevieve, I can send your email and phone number out with
Oh, perfect.
recording
Yeah.
too, just in case. Yeah, I'll definitely.
Yeah, that would be great.
Well, thank you everyone for attending today. We'll send this information out shortly. And Genevieve, thank you so much for doing this for us again. It's always nice to see you and hear all of this information. It's a lot, so hearing it multiple times is very good. Thank you.
You're welcome.
Genevieve,
Okay.
are you okay? I took a screenshot of that last slide that you had up. If I put your name on it, can we put it on our social media for people to kind of see what you were talking about?
Yeah, totally.
Okay, great.
Yeah,
Thank
can
you.
do that. You're welcome.
Thank you. It was awesome.